Yes.
You gonna make a movie of this?
Yep, I am.
Good. In adults who have aortic stenosis that causes fainting, angina, or shortness of breath during exertion, the aortic valve is surgically replaced, preferably before the left ventricle is irreversibly damaged. Echocardiography, usually performed periodically, can help doctors determine when to schedule surgery. Before surgery, heart failure indicated by shortness of breath is treated with diuretics. Surgical replacement of the abnormal valve is the best treatment for adults of all ages, and the prognosis after valve replacement is excellent. People with an artificial valve must take antibiotics before a surgical, dental, or medical procedure to reduce the risk of an infection on the valve infective echocarditis. For children who have severe stenosis, surgery may be performed even before symptoms develop, because sudden death may occur before symptoms develop. Safe, effective alternatives to valve replacement are surgical repair of the valve and balloon valvuloplasty. In balloon valvuloplasty, a balloon-tipped catheter is threaded through a vein and eventually into the heart. Once inside the valve, the balloon is inflated to expand the valve opening. However, later, when children are fully grown, the valve usually must be replaced. In adults, stenosis always recurs after balloon valvuloplasty, so among adults this procedure is used only for frail older people who cannot tolerate surgery. Tricuspid regurgitation, tricuspid incompetence, tricuspid insufficiency is leakage of blood backward through the tricuspid valve each time the right ventricle contracts. As the right ventricle contracts to pump blood forward to the lungs, some blood leaks backward into the right atrium, increasing the volume of blood there. As a result, the right atrium enlarges, and pressure in the veins that enter the right atrium is increased, creating resistance to blood flow from the body to the heart. Tricuspid regurgitation usually results when the right ventricle enlarges and resistance to blood flow from the right ventricle to the lungs is increased. Resistance may be increased by a severe, long-standing lung distension or by narrowing of the pulmonary valve, that is, pulmonary stenosis. To compensate, the right ventricle enlarges and thickens so that it can pump harder and the valve opening stretches. Other, less common causes are infection of the heart valves, infective endocarditis, use of fenfluramine, birth defects of the tricuspid valve, injury, and myxomatous degeneration, a hereditary disorder in which the valve gradually becomes floppy. Tricuspid regurgitation can cause vague symptoms such as weakness and fatigue. They develop because the heart is pumping a smaller amount of blood. Usually the other symptoms are pulsations of the neck and discomfort in the right upper part of the abdomen due to an enlarged valve. These symptoms develop because blood flows backward from the heart into the veins. Enlargement of the right atrium can result in a rapid, irregular, irreversible heartbeat or atrial fibrillation. Eventually, heart failure develops, resulting in accumulation of fluid in the body, mainly in the legs. The diagnosis is based on the person's medical history and results of a physical examination, electrocardiography, and chest x-ray. Through a stethoscope, doctors can hear a characteristic murmur produced by the blood leaking backward through the tricuspid valve. Echocardiography can produce an image of the leaky valve and the amount of blood leaking so that the severity of the regurgitation can be determined. Usually, tricuspid regurgitation requires little or no treatment. However, the underlying disorder, such as emphysema, pulmonary hypertension, or pulmonary stenosis, may require treatment. Good afternoon, Mr. Olstein. Can you tell us if you are presently employed? I am. By whom are you employed? Bow Industries. And Bow Industries do any business under the name of Red Hook Realty, Inc.? No, Red Hook Realty is a separate company. How do you know Red Hook Realty, Inc.? It has similar ownership as Bow. And who are the other principals of Red Hook Realty? Defendant's counsel objection. The court objection is overruled. The principals, I don't recall. Do you have any relationship with Red Hook Realty, Inc.? I'm an officer. What is the purpose of Red Hook Realty, Inc.? Red Hook Realty is simply a company that owns a building. What is the address of that building? We refer to it as 73rd Avenue. That's in Glendale, Queens. Is that the only property that Red Hook Realty owns? Yes. What year did Red Hook Realty buy the property? Defendant's counsel, I object. Irrelevant. The court overruled in 1993. Now, if we refer to that piece of property as the premises, you'll understand? Yes. When Red Hook purchased the premises, were there any tenants in that building? Yes. And who was the tenant at that time? The main tenant, I don't recall who the main tenant was. There was an ancillary tenant, which was Fabric Design. And for what purpose did Red Hook purchase that building? It was an investment, just a real estate investment. What happened to the other tenant other than Fabric? I presume they moved. Did they move prior to your purchase of the building? I don't recall. At any time, did any company that Red Hook Realty may have an interest in move in as a tenant? Defendant's counsel, irrelevant. The court overruled. After the purchase, you mean? Yes, after the purchase. Well, after the purchase, Bow Industries moved in. And that's the company that you actually work for? That's correct. And what is the purpose of Bow Industries' business? Bow Industries, the nature of the business, you mean? We're screen printers. We print garments. When you purchased the building, was there an existing lease between the tenant and the previous owner? Yes, there was. At that time, did you designate a new lease or did you assume the old lease? I'm not sure. Do you remember how much time was remaining on that old lease? Defendant's counsel, objection, Your Honor. The court overruled. That's a yes or no. I don't recall. At any time after Red Hook Realty purchased the premises, did you in fact negotiate a new lease with Fabric for its tenants? Yes. Do you remember what year that was? I don't recall specifically. I believe it was 1995. Plaintiff's counsel, Judge, could we just show the witness a copy of the lease? The court, has that been marked? Plaintiff's counsel, I believe so, yes. The court, it's marked and in evidence. Take a look at that. Sure. I'm going to ask you to take a look at what has been marked as Plaintiff's Exhibit 1. Does that refresh your recollection? Yes. Of the year, what was it? 1995. What was the actual term of the lease? 2 years, 9 months. And were there payments to be made on a certain schedule? Defendant's counsel, objection. The court overruled. The payments are made monthly. How much were the monthly payments? $5,761.47. With respect to rent payments, did Fabric comply with the requirements of the lease on a monthly basis? They often complied. They were often late with their payment, but for the most part they complied up until the event which brought us here today. Were there any demands for payment made to Fabric during that time? They weren't made by me. No. They were not made by you? No. Can you identify for us what that document is? I can. I've never seen it before, but I can tell you what it is. If you know, what is it? It's a statement of rent due. Can I borrow your stapler? This part came apart, sorry. It's a statement of rents owing and payments made between Fabric and Red Hook Realty and showing a balance due in arrears of Defendant's counsel. At that point, we have to object, Your Honor. I don't want him to testify about the contents. He said he never saw it before. The court, well, if this is being offered in evidence, the witness said he's never seen it before. No foundation. Plaintiff's counsel, well, Judge, I was going to ask him if that's the type of document that would be generated as a business record as part of the business of Red Hook Realty. The court, well, we need some foundation as to whether or not he would know that. Mr. Bowles, was it in the regular course of your duties with Red Hook to examine the rent bills that went out? No, it was not. Who would be responsible for that? Daniel Brash. And as far as you know, were there rent payment bills sent out every month as part of Red Hook Realty's business? I don't know. Defendant's counsel, then, Your Honor, I won't offer it. Can I have this marked? Mr. Bowles, can you tell us what that is? Yes, it's a letter from Dan Brash to Marvin Still, notifying him that he's in default of his rent. Defendant's counsel, I object to testimony as to its contents, Your Honor. The court, go ahead. Mr. Bowles, do you recognize whose signature that is on the bottom? Yes, and whose signature is that? Daniel Brash. How do you know that to be Daniel Brash's signature? I've seen him sign his name thousands of times. And is that the type of document that would be prepared in the regular course of business of Red Hook Realty? Yes, in fact, I've seen this document before. And was that document, in fact, prepared in the regular course of Red Hook Realty's business? Yes. And was it done at or around the time that the demand for unpaid rent was made? I don't know. Defendant's counsel, Your Honor, I would like to offer that into evidence. Plaintiff's counsel, very brief voir dire, Your Honor. The court, all right, you're entitled to that.
I didn't get it. I was way too fast.
Okay. Frankfurter's opinion made it clear that he believed the flag salute was closely connected to a potential war effort. We are dealing, he wrote, with an interest inferior to none in the hierarchy of legal values. National unity is the basis of national security. Patriotism, in turn, was the glue that held the nation together. The flag is a symbol of our national unity, transcending all internal differences, however large, within the framework of the Constitution. As a coda, Frankfurter quoted Holmes, "We live by symbols." To produce a canonical opinion, Frankfurter needed to explain why deciding against the witnesses was not a blow to civil liberties. Frankfurter saw himself as a civil libertarian. Before joining the court, he had been a member of the ACLU's National Committee, and the ACLU had filed a brief in the case on behalf of the witnesses. He explained that in his own individual view, the school board should allow the witnesses' children not to salute the flag. The best way to establish national unity, he said, was not by forcing everyone to conform, but rather by tolerating idiosyncratic beliefs, however crotchety. But Frankfurter went on to explain the job of the court was not to decide whether the school board had followed the best course of action. It was indeed to ascertain whether the school board had made a reasonable choice in requiring the children to salute. This formulation of the issue led Frankfurter to the idea of judicial restraint. Frankfurter argued that the Minersville School Board had to be treated as though it were the state legislature itself, reflecting the democratic will of the people. According to the philosophy of judicial restraint, the judiciary was supposed to defer to reasonable judgment made by the legislators, not overturn them because it disagreed with their substance. According to Frankfurter, the question before the court was whether the witnesses were entitled to a religious exemption from a law that bound everybody. On this point, Frankfurter could offer a clear answer, one with strong constitutional precedent behind it. The First Amendment guaranteed the free exercise of religion, but it did not provide for any automatic exemption. Among the cases Frankfurter cited in support of this proposition were decisions rejecting challenges to the draft during World War I. Frankfurter concluded that the school board could choose to give the witnesses an exemption from the flag salute requirement, and maybe even should do so, but that the Constitution did not require such an exemption. Leaving the decision up to the legislative body was the hallmark of judicial restraint. Frankfurter was proud of his opinion. He believed he had shown how liberal constitutional theory worked in practice. It respected civil liberties without interfering in legislative judgment, and it was able to recognize important political values like the need to promote national unity. The other Roosevelt appointees to the court agreed. As Roosevelt had expected, his appointees were forthcoming as a team. Black joined the opinion gladly. Douglas told Frankfurter the draft was historic and truly statesmanlike. Also joining Frankfurter was the amiable, dull Stanley Reed, the former Solicitor General. Considerably more interesting was the newest justice, Frank Murphy, who had come on in the spring of 1940, giving Roosevelt a total of 5 appointees. A committed Catholic who never married, Murphy lived for most of his life with the same man, Edward Kemp, who also worked alongside him in a variety of jobs. Murphy got his political start as a pro-union, pro-African-American mayor of Detroit. Spurred, at least in part, by Murphy's Catholicism, Roosevelt appointed him Governor General of the Philippines. Murphy presided over the drafting of the Constitution of the Philippines and the transformation of his own job onto that of High Commissioner. He then returned to Michigan and was elected to a 2-year term as governor. When he was not re-elected in 1938, Roosevelt appointed him as Attorney General, in which position he pursued communism and political issues and created a civil liberties and within the criminal division of the Department of Justice aimed at enforcing federal civil rights statutes around the country. This was the career of a distinguished public servant, yet Murphy's fellow liberals discounted him. Robert Jackson had hoped to become Attorney General when the job went to Murphy and remained as Solicitor General on Roosevelt's promise that he would replace Murphy soon. As Murphy's White House swearing-in ceremony, a friend of Jackson's observed, "Bob showed no sign of regret, but if I ever saw regret, it was written on the face of Mr. Jackson." Working under Murphy in the Department of Justice, Jackson was horrified by what he saw. Murphy had the least knowledge of federal procedure or federal law or the limitations on the federal government of any man in such a responsible position that I ever knew. When Jackson, who did not shrink from using anti-Catholic imagery in discussing Murphy, was an ideological crusader driven by fanatical priestly pretensions of his own holiness. Jackson practically begged Roosevelt to fire Murphy from the Attorney General post. But as a politician with a substantial Catholic constituency, Murphy could not be touched. The most Roosevelt could do was keep Murphy from becoming Secretary of War, a post he craved. When the only Catholic on the Supreme Court resigned, Roosevelt put Murphy in his place. If, as Attorney General, Murphy sometimes seemed like an inquisitor on the Supreme Court, he emerged as a thoroughgoing liberal. Siding instinctively with the underdog, he would go on to write many dissents, one of them among the bravest in the history of the Supreme Court. The other justices found him a figure of fun. There he goes, they would say, tempering justice with Murphy. Perhaps as a result of his colleagues' ribbing and his own lack of interest in the technical side of the law, Murphy was deeply unhappy on the Supreme Court. During oral argument, he would write notes to Frankfurter, writing Frankfurter would get him appointed ambassador to India or another of his fantasies to enable him to return to the Philippines and lead a rebellion against the Japanese who occupied the island in 1942. Now, you asserted to this jury that there came a point in time when you eavesdropped on conversations between my client and Daniel Ryan. Is that correct? Yes. Where did that talk take place? At the corner. Is it your sworn testimony that when you first saw him, you approached him and asked him if he had a cigarette? Defendant's counsel. Objection. As leading, Your Honor, the court. The objection is overruled. Yes. Isn't it a fact that the reason you asked him if he had one is because you wanted some yourself? Yes. Isn't it a fact you smoked every day? The court. Can you slow down? Yes, we all smoked every day. I did not ask about everybody else. I smoked every day. And like 3, 4, 5, 6, 7 times a day, right? Yes. And you smoked marijuana when you were awake and moving about like every 2 hours or so? Excuse me? When you were up and awake and out and around, you smoked about every 2 or 3 hours, right? Yes. At the time you approached Daniel, you wanted your cigarette for that particular time of the day, right? Defendant's counsel, objection. Leading, Your Honor. The court, the objection is overruled. Yes. And he told you he did not have any? Yes. So how much longer after you had a conversation with Daniel was it before he started working on the street? How much longer? Yes. I don't remember. Wasn't it around 20 minutes, a half hour? Defendant's counsel, objection. Leading, Your Honor. The court, the objection is sustained. I don't know. The court, don't answer when I sustain an objection, Mr. Witness. Sorry. It was a long period of time? Yes. Give us an estimate. Like 10 minutes, 15 minutes? He was coming down Livingston Street? Yes. And I spoke to him. I said, what's up? I gave him a handshake. I asked him if he had a cigarette. What did he say? He said no. Then what happened? Then he seen this other guy coming down the street. And it's your testimony that at a time when withdrawn, when you brought these substances, didn't you buy it only in that area? Not only in that area. Did you buy it in that area? Yes, at times. You knew lots of places you could go to get marijuana. Is that correct? Yes. You went to those places numerous times to get it? Yes. And it's your testimony to the jury that when you wanted it, you would ask Daniel for it, and he would say he does not have any? No. And lo and behold, this guy was walking down the street? Yes. The court, please save the histrionics for summation counsel. It is bad in form. There came a point in time that Larry was walking down the street? Yes. What time of day was that? I don't remember. In an effort to refresh your recollection, you got up that morning to go to work, right? Defendant's counsel, objection to leading, Your Honor. Also, it is bad in form. The court, I will allow it at this point. Yes. You approached the building? Yes. And you saw that it had been blocked off? Yeah, right. So you could not get in, right? Yes. Didn't you tell the jury you knew instantly when you got there, the moment you got there, as soon as you got there, yes, that these detectives were from homicide, as you said? Yes. They were detectives, right? Yes. They didn't have a sign or a badge saying homicide? No. Did you say you've seen Detective Heffler before? Yes. Whereabouts? In the area. And other detectives? Yes. You've seen other detectives, right? Yes. Is there any sign that would let you know that this detective is a homicide detective and the other detective was a robbery detective? I don't understand the question. Defendant's counsel, objection. Was there tape there? Yes. The building was surrounded with orange tape. Did that tell you something? That when there's orange tape around a building, that's more or less a clue that somebody has been killed. More or less, but it could have been something else? The court, had you seen that before in your experience, the orange tape? Yes. The court, had you learned what it meant from that experience? Yes. Isn't it a fact you knew there were homicide detectives because you were on the roof when the victim was killed, and you knew there was a murder and on that roof, and that is why you knew automatically? The court, do you want an answer, or do you just want to hear yourself ask a question? Plaintiff's counsel, I beg your pardon. The court, it's the answer taken with the question, if believed by the jury, which is the evidence you asked about these questions before. Isn't it a fact that you knew, the court, please slow down, ask one question at a time. Isn't it a fact that you knew the moment you got there that they were homicide detectives because you knew that the victim had been killed on that roof? To the court, you know how to conduct yourself properly, please do it. Plaintiff's counsel, yes, Your Honor. The court, were you on the roof? No, I was not on the roof that night. What were you doing? I was in my house. I had to get up to go to work to go and open up a vendor spot. Do you work from 8 to 4? Yes, the other guy works from 12 to 6. The court, I guess that's developed. He's developing this habit of a compound answer based on your compound question. Defendant's counsel, I move to strike it. It should not be permitted by the court. The court, if both of you follow the rules, will be okay. Ask your next question. You have an urge or some need to volunteer damning evidence against the other guy? The court, please, sir, ask your next question. Don't make statements. You don't recall around that time while the conversation took place, am I correct? Yes. But you remember you woke up and you went to the building and you saw there was tape there, right? Yes. And then you went to see some guy? The court. Don't lead, please. How's that?
Bullets and stuff.
190.
Yep, go ahead.
Do you understand French? Yes. You will be testifying through the interpreter? Thank you. Where were you born? Haiti. When did you come to the States? What? When did you come to the American continent? 13 years ago. How far in school did you go? What do you mean? The court. What level of education? In the school? The court. Yes. Second year of the system. College or high school? High school. How old are you? 40. How many children do you have? Excuse me? How many children do you have? 6. What are their ages? Defendant's counsel. I object on the ground of relevancy and materiality, if the court please. The court. Your objection is overruled. What is the answer, please? 25, 21, 20, 18, 16, and 14. David is your son? Yes. Is that your older son? Yes. I would like to direct your attention to December 21, 2007. Where did you live at that time? In White Plains. What apartment? 1A. Can you tell me what apartment you lived in at that time? Yes, I can. Tell us. I said 1A. How did you come to live in that abode? I was coming from Haiti. I went on welfare. I went to my aunt's house. That is what they gave me a check for. You came from the West Indies? Yes. You were living in your aunt's house? About a week after I went to the Hotel Prince George. The Prince George Hotel? Yes. Where were you the afternoon of December 7th, 04? In my house. What were you doing in your home that PM? I was looking and I had stereo. Was David your son in your abode that afternoon? Defendant's counsel. I object to the leading at this point, Your Honor, and ask Your Honor to admonish counsel not to lead. The court. Don't lead, if you please. He had arrived between 4 and 5 from work. What did David do, if you know, when he got home from work? He came in. He asked me, Mom, serve me because I'm starved. He checked the food, went to the room. He told me he was going to clean up first. What room did he go to? To his room. Plaintiff's counsel. Your Honor, with the court's permission, I would ask that we put that what is characterized as People's Exhibit 1 in evidence on the easel for all to view. The court. It will be put on the easel by the court officer, yes. Would you please take a look at People's Exhibit 1 in evidence, which is to your left up on the easel? Yes. Do you see that diaphragmatic sketch? Yes. How does it compare to your apartment in 1A? It looks like the apartment I used to have. Is it your apartment, yes or no? Uh-huh. The court. Please say yes or no. Don't say uh-huh. Yes. Plaintiff's counsel, with the court's permission, I ask the court's officer be permitted to hand the pointer to the witness. The court, certainly. If you can, just stand up a little bit and approach the diagram. Okay. Would you point to David's room? Here. Are you familiar with your son's grooming habits? Defendant's counsel, I object to the form of the question if it please the court. The court. The objection is sustained. Now, the apartment you used to live in, how was the radiator in that apartment? It was hot. And what were his habits, if you are familiar with your son's habits in terms of keeping his window open? What do you mean? Defendant's counsel, I object. The court. Objection sustained. Are you familiar with your son's habits in relationship to keeping his window open or closed? Defendant's counsel, I object. The court. Objection sustained. What, if anything, unusual happened that afternoon in your building? I was in the kitchen. Someone knocked at the door. Did you answer it? I opened the door. Who was there? It was one of my son's friends. Who was your son's friend that had knocked on the door? His name is Paul. Did you say that your little daughter had said, Mommy, there is someone saying that a man is screaming? Defendant's counsel, I object on the ground of hearsay, and what's more, contrary to fact, if the court please. The court, I think that was testified to yesterday without objection. The objection is overruled. Defendant's counsel, objection to form, Your Honor, as well. The court, the objection is overruled. That you could hear because someone was screaming from the top of their lungs as they were coming down the stairs. Which of your daughters made that statement? The one who was coming from the Girl Scouts. How old is she? Now? No, then. She is 20 now. I do not know how old she was then. Was she 13? 13, yes, that sounds right. What is her name? Iris. The man that was screaming and running down the stairs, do you see that person here in this courtroom? Yes. The man over there with the green suit on? Defendant's counsel, indicating the defendant, I will concede. The court, all right, you have your concession, counsel. Had you ever seen the defendant before that day? Yes. From where did you know him? From the building, from in front of the building, the stairway. Did you know where he lived? Exactly, no. Did you have knowledge of what building he lived in? They used to come up to the hall where I lived. Did they go past your floor? Yes. Do you recollect if he lived with anyone, the defendant? The court, I don't hear your answer. From what I understand, he used to live with a lady. Did you ever see him with another woman in the building? No, just that same lady. Would you see them from time to time in the building together? Uh-huh. The court, please answer yes or no. Yes. The woman you are talking about? Yes. That woman died this afternoon. Defendant's counsel, objection, leading. The court sustained. 200. Other than your efforts on behalf of the candidacy in 2003, have you made any other efforts on behalf of any candidate for Supreme Court at all? Not that I recall. When a delegate is elected and doesn't appear at the convention, do you have any knowledge of what happens then? My understanding is that the party chairman chooses an alternate to take his place. If the alternate is there, and if there is not an elected alternate, the party chairman chooses alternates. What is the basis of that understanding? Maybe from my hearing about the convention, maybe from the complaint, I don't know. Prior to reading the complaint, did you in fact have any understanding or knowledge of how a vacancy gets filled if a delegate and alternate are not present? Defendant's counsel, objection. The court overruled. You may answer, I don't know. Have you ever looked at the statute to determine how the delegates and alternates are selected? I don't remember. Have you ever looked at the statutes to determine how a vacancy at the convention is filled? I don't remember. If I told you that the statute requires that the vacancy be filled by those delegates and alternates from the assembly district who are actually in attendance, would that refresh your recollection at all? Defendant's counsel, objection. The court sustained. Next question. When you were a delegate, were there people in attendance from your district to cover the total number of delegates who were entitled to it? Defendant's counsel, objection. The court overruled. Answer the question. I don't know. How many people were you to go to the convention with? I don't remember. Do you remember anything about the convention other than it was at the Supreme Court building and Harold Fisher made a statement? Defendant's counsel, objection. The court overruled. Other than what I told you, no. So you don't know how a vacancy gets filled at a convention, do you? Defendant's counsel, objection. The court overruled. I don't know for certain how he gets filled. How many votes does it take to get nominated as a Supreme Court candidate for the 2nd Judicial Department? I don't know. What is the basis of your stating that to get nominated would require running 305 delegates and alternates? Can you tell me where I said that? I believe it's paragraph 33, page 13. I did not say it. Did you authorize anybody to make that representation in the complaint on your behalf as plaintiff? Defendant's counsel, objection. The court sustained. Don't answer. What is it based on? Defendant's counsel, objection. The court overruled. Well, as you know, I rely upon experts in election matters to fill you in on the details, but it seems to me that if you need to get a majority of the delegates in order to nominate somebody or to get the Democratic Party nomination, and there are 305 delegates, then It is based on who runs and in all the districts for every slot in order to try to win a majority. Defendant's counsel, move to strike is not responsive. The court, strike it out. You only had to elect a majority, is that correct? You need to have a majority in order to get the party nomination. But you don't need all of the delegates. You don't need all of the delegates. Are you familiar with the Kings County Democratic Coalition? Yes. When you were president and a delegate to the Judicial Convention, was that not a part of the Kings County Democratic Coalition? We were a part of it, yes. Wasn't it a group of clubs from a number of different assembly districts? At the time I was president, I don't think it was much of anything. It was formed before I was there at some kind of an organization of reform clubs in Brooklyn. I don't think it was doing very much when I was president of it. Do you know how many clubs were part of it? No. Did you inquire as to whether or not there were other people of like mind running delegates to the Judicial Convention when you ran? Defense counsel, objection. The court, as to form, sustained. Did you make such inquiry at any time when you were involved in electing delegates in Kings County? Defense counsel, objection. The court, overruled. I don't remember. Are you familiar with Mel Miller's club? Yes. He was an elected public official? Yes. Was he able to get himself elected? Yes. It was also Liz Holtz's club, was it not? Yes, it was. Mr. Miller ultimately became Speaker, did he not? Yes. So he was an influential personality within the Democratic Party in Brooklyn at that particular period of time, was he not? Yes. He came from the reform wing of the party, did he not? I don't know where he came from. When he was your boss, were you aware of where he was coming from? Defense counsel, objection. The court, bad in form, but I will allow it. When I was in the place, I don't think it regarded him as part of the reform wing. Who did it regard as the reform wing at that time? Defendant's counsel, objection. Irrelevant. The court, sustained. Next question. Is it not a fact that, generally speaking, the Democratic Party considered only the club to be the true and pure reform movement in Brooklyn? Well, I was in there, and I would say Milton Gold regarded only himself. Some of the members of the club regarded themselves as the only pure and true source, would you say? Defendant's counsel, objection. The court, overruled. I will allow it. There were some members like that. I don't remember. I know we worked with them, as I said. Isn't the club, in fact, in the 52nd Assembly District? Yes. It has always been in the 52nd Assembly District? Yes. So you are aware of the 52nd Assembly District? I'm aware of it. And it abuts the 51st? Yes. You asked me what street the line was on. I can't tell you what street it's on. I think I first asked you what the abutting or adjoining districts are. We still come back to that. We'll skip what I did or did not ask you. Unless your counselor says it's a question that I have already asked and answered, I will just ask it again. Did other related reform clubs work together in your experience? Sometimes. In an effort to elect candidates of their choice? Sometimes. And in an effort to expand beyond their own district when the office or party positions sought was beyond its own geographic sphere of influence. Is it correct to say that CBID and IND work together? Defendant's counsel, objection. Ready?
Yes.
The court packing plan strengthened Jackson's ties to Roosevelt. During the fight, he had shown himself to be an effective advocate in the Senate, not to mention a deft expositor of legal arguments to the president. His advice had not exactly been taken, but neither had it been rejected. More important, since Jackson had from the start claimed that the purpose of the court packing plan should be to get the court to change its views, the fact that the court had in fact switched provided a basis for claiming that the whole undertaking had been a success. And since the plan had failed to be adopted, it became especially important to Roosevelt, always focused on winning, to explain that it had in fact been a victory. Jackson was the natural person to take up this task. Within a few months, he began work on what would become a 400-page book offering a historical justification for the plan, as well as a detailed accounting of why it had ultimately been a success. Titled The Struggle for Judicial Supremacy, it was written over the course of the next 4 years, during which time Jackson was promoted from one assistant attorney general position to another, and then in March of 1938, barely a year after the court packing plan was first introduced, to Solicitor General of the United States. That Jackson would undertake such a project while serving on high government office was a mark both of the importance of court packing plan to Roosevelt's perception of his own legacy, and also of the personal stake that Jackson took in the plan that had brought him into Roosevelt's inner circle. In fact, it is difficult to think of a comparably significant and sophisticated book ever written by a senior administration official while in office. Although it naturally reflects Jackson's distinctive substance-oriented view of the court-packing plan, the book is no simple political manifesto. It offers nothing less than a practical-minded account of the proper role of the judiciary in relation to the political power, which is the power of the voters, the economic power of property, which is the power of its owners, and the other branches of government. When Felix Frankfurter sat down to write his own books and articles on the Supreme Court, he was already an eminent professor sitting in the very law school that had educated him, given him an entree to Holmes and Brandeis, and promoted him to the front of the legal elite of the nation. Jackson held high office, to be sure. He had the benefit of extensive advice and drafting help from Paul Freund, who worked in the Solicitor General's office and later became an important Harvard professor and nearly Solicitor General himself, and from Professor Louis Jaffe, then teaching at the University of Buffalo Law School, later also a Harvard giant. But Jackson's preparation for writing this book was no greater than his 20 years of legal practice and his brief run in Washington, none of which involved constitutional law, much less the Supreme Court. An author of legal briefs and many speeches, Jackson had never before written a law essay, much less a book-length treatment of an important legal topic. The struggle for judicial supremacy was not merely an attempt to make sense of the court-packing plan in a way that would appeal to Roosevelt and to history, but equally important, it was Jackson's own intellectual effort to teach himself about the Supreme Court and its role in American public life. Like the well-prepared lawyer that he always was, when embarking on a career as constitutional advocate before the court, Jackson wanted to have a deeper understanding of just what he was doing and why. Seen in this context, the focus on the court-packing plan makes a great deal of sense, because the court before which Jackson regularly appeared was the product of that fight. The book is also the first attempt made by Jackson to offer a comprehensive history of the Constitution and how it should be interpreted, a theory he would later develop in a remarkable set of judicial editorials. In language so clear it could serve as a model for writing about constitutional issues for a general audience, Jackson begins by explaining that the Constitution itself nowhere gives the Supreme Court the authority to decide on the constitutionality of federal legislation. This power was the result of historical development, not the Constitution's text or structure. Constitutional difficulties cannot be resolved simply by looking to the document or to the intentions of those who wrote it. The right way to proceed must be elsewhere. How's that?
That's fine.
It was 140. Did this all take place in the village of Ardsley? Yes. Is it your testimony that Mr. Muldoon did not work on this job? Defendant's counsel, of course he worked on this job. Plaintiff's counsel, I move to strike counsel's unsolicited statement. The court, the motion is granted. You know that is improper, counsel. Defendant's counsel, I object to it because there is no claim made for this salary. The court, overruled. It is proper in light of the bill of particulars. I want some corroborative sheets from which this was made up. Defendant's counsel, objection to the form of the question, Your Honor. The court, the objection is sustained. Did you look for them? I don't keep tabs on that. Is there a record or a timesheet? Yes. Could they continue to do their work to your knowledge regardless of how long it takes to finish? Oh, that is a separate unit. So they continue to do this work? Yes. And their work consists of following certain plans? Defendant's counsel, I object on the ground of leading, Your Honor. The court, the objection is sustained. The plans are made up by whom? Our sketchers. Then you draw sketchers from that? That also. Was there any extended time in the fabrication of ducts to your knowledge? Defendant's counsel, objection as immaterial, Your Honor. The court, the objection is overruled. When you say extended time, from what point? Was there any lull? Yes. You always had labor there, isn't that right? The shop did not fabricate on schedule, though. What stopped the shop from fabricating on schedule? I couldn't answer that. Is there any book that you have that would tell us that? Yes. What book or record? The contract numbering system that we used. Do you have that? For what year? I want it for years in question. I'm not sure. Aren't they permanent books of account? They are internal control records. We don't keep internal control records that long. Defendant's counsel, if Your Honor, please, before counsel proceeds any further, I would like the witness to bring these books tomorrow or this afternoon. It is very important to this case. The court, would it be convenient? The witness, our place of business is quite a distance from here, Your Honor. Defendant's counsel, can't she go to Cold Spring Harbor and bring them back today? The court, I just asked if it would be convenient. The witness, it would take me quite some time. The court, tomorrow. The witness, tomorrow is all right. The court, then we will adjourn. Please retire, members of the jury.
That's pretty tough.
Pretty snappy. Members of the jury, we have now reached that point in the trial when I will inform you concerning the law and you will begin your deliberations. I shall apportion my instructions in 3 categories. Initially, I shall give you the general precepts of law which apply to this case and all criminal trials. Many of these aspects of law you have heard me explain at the beginning of the trial. I'm sure you appreciate the benefits from impressing the legal subtleties at this stage of the proceedings. Secondarily, I will instruct you with respect to the law as it flows from the particular crimes you will consider. I will define the charged crimes. I will then break down the definition of charged crime into its component parts and what the law refers to as the components of the crime. Thirdly, I will explicate the process of deliberations. I will not review or capsulize the evidence. I may refer to particular evidence to explain a point of law. Do not draw any conclusions from a reference to the evidence or from the absence of a reference to any evidence that I have any opinion about the importance of any particular evidence. I have no such opinion. Again, my reference to proof is only when I believe it necessary to the constitutionality of the law. You and you alone are the exclusive judges of the evidence. I may, during these instructions, by the level of my voice or by intonation, seem to emphasize certain matters. That is an irrelevancy in this case. To help you understand the important principles of law, it is not intended to communicate any viewpoint vis-a-vis the facts. Remember, you and I are sitting here together as judges, you as judges of the facts and I as judge of the law. You must rely upon and follow the principles of law as I define them, whether you agree with them or not. You have no discretion to depart from the principles of law as I explain them. As judges of the facts, you must weigh and evaluate the testimony and other evidence and determine what the facts are with respect to what, if anything, took place at the time and place in question. After you have ascertained the facts, apply the law as I have explained it to the facts, and render a verdict of guilty or not guilty as to the charged crime. It is your solemn duty to decide the case predicated on the evidence and the law without fear, favor, sympathy, or prejudice. During the trial, as the judge of the law, I made rulings on objections and applications by the lawyers. You are not to draw any inferential conclusions for or against a witness, the people, or the defendant from these jurisprudential rulings. You are not to take into account anything I said during the trial, or any interrogations I made, or rulings, pronouncements, or anything that I may say to you in this course of this charge, as indicating that I have an opinion on this case one way or the other. I have no such opinion. You are the determiners of the facts, not I. In evaluating whether the defendant is guilty or not guilty, you must not surmise or speculate about matters relating to a possible sentence or potential punishment. If there is a verdict of guilty, the court and the court alone metes out the sentence. Members of the jury, with respect to the summations of counsel, as I have previously indicated, you are not mandated to accept the argumentation of the lawyers which were made during the summations. If you find that a particular lawyer's analysis of the evidence is on target, and if you find that the inferential conclusions which you are asked to elicit from the evidence are reasonable, logical, consistent, and consonant with the evidence, then you may adopt such inferential conclusions either in whole or in part. On the other hand, if you believe that either attorney's analysis of the facts or of the inferences or conclusions which you have been asked to draw therefrom are illogical, inconclusive, or not warranted by the evidence, then you may disregard them either in whole or in part, and delineate your own conclusions from the evidence which you believe to be verifiable. Remember, nothing that the lawyers said in their openings or in their making of objections or applications or in their summations or at any other time is deemed evidence in this case. Also, it is your own recollection, understanding, comprehension, and evaluation of the facts presented by the evidence at this trial which controls, regardless of what the lawyers on either side of the case may have said about the facts. You, and you alone, are the sole and exclusive judges of the facts in this case. When you judge the facts, you are to consider only evidentiary matters which were admitted into evidence. For example, in this case, you heard an allusion to an indictment. An indictment is not evidence. The indictment is simply a piece of paper containing written allegations of criminal charges. It is the personal device used to bring a defendant to court for trial. It has no other significance or meaning. It does not prove or tend to prove the defendant's guilt. By his plea of not guilty, the defendant denies each and every allegation contained in the true bill returned by a grand jury. The evidence in the case, succinctly stated, is the sworn testimony of the witnesses on direct examination and cross-examination, the exhibits the court permitted to be received and marked into evidence, and the stipulations the attorneys agreed to during the trial. Testimony, the interrogations, and the responses of witnesses which were stricken from the record as to which an objection was sustained must be disregarded by you. Exhibits which were seen during the trial or marked for identification but not received in evidence are, of course, not evidence and are thus not available for your inspection and viewing. However, testimony based on exhibits that were not received in evidence may be considered by you, but the exhibit itself, not having been received in evidence, is not available for your inspection and viewing. In evaluating the evidence, you may consider such facts which are proven and conclusively inferences which may be drawn from such facts. To delineate an inference means to find that a fact exists based upon proof of some other fact. For example, you go to bed one night when it is not raining. When you wake up in the morning, you look out your window and you do not see rain, but you see water on the street and people in raincoats carrying umbrellas. Under those circumstances, the conclusion is reasonable that there has been a rain during the night. In other words, the fact of rain is an inference that might be drawn from the presence of water on the street. An inference may be drawn only if it is reasonable and logical, not if it is speculative or conjectural. Therefore, in deciding whether to draw the inference, you must look at and consider all the facts in the light of the common sense and experience. After you have done that, the question whether to draw a particular inference is for you to decide. With respect to a question alone, remember, you are not to draw any inference, either favorable or unfavorable, to either side from the fact that a question was asked in the first place. Questions alone are not evidence. You are not to conclude just from a question alone that anything assumed in the question is true, no matter how detailed or specific the question was. You must consider the question along with the witness's answer and decide whether you find the answer credible and reliable. Each of you has it within his or her power to draw proper, reasonable, and just inferences from the testimony and exhibits in evidence. When you draw an inference from the evidence, there are two things you should keep in mind. The defendant is entitled to every inference in his favor which can reasonably be drawn from the evidence. 2. Where two inferences can be drawn from the evidence and both are of equal strength and weight, and one inference is consistent with guilt and the other inference is consistent with non-guilt, you must choose the inference consistent with non-guilt. At the same time, other considerations that may cross your mind, such as sympathy, vengeance, prejudice, or bias of any kind, must be completely disregarded by you in your deliberations.
Okay, all right.
Okay. President Bush wants to create a new class of temporary workers in America. As he said in his immigration proposal last week, he expects these workers to spend several years here, and he would offer them incentives to return permanently to their home countries. This is a reasonable idea, but unduly limited. It is clear that there are lower skilled workers that are open and that there are many eager to come, earn higher wages here, and then return to the. At the same time, some should be able to seek permanent residency. Moreover, the history of guest workers in America is a brutal one, filled with abuse by employers and the government, as well as legitimate concerns by American workers. The challenge for the President, the Congress, and the leaders of nations that would provide the new class of workers will be to find a better way to serve their needs. Ensure.
I need to read something else. Can't read that.
Ready?
Yeah.
What I am asking you, madam, is on August 3rd, 2005, you couldn't have meant that his ulcer was improving because, in fact, it wasn't improving. Is that correct? So you couldn't have meant that? Defendant's counsel, objection, Your Honor. The court, yes or no? You can't answer? I can't answer the question, yes or no. You say you can't answer it. Nonetheless, you agree that you continued the same orders you had given before, correct? Yes. Now, please direct your attention to the note of August 17th,